This is a doggone pretty good article. What I've been saying all along, the government has no power. They were never given any power to mess around with any of your rights. Period. No question mark. Since America's latest episode of mass homicide has sparked renewed advocacy for restrictions on gun ownership. Once again, the accompanying debate has many gun control advocates claiming the Second Amendment reference is a well-regulated militia narrows the amendment's scope, if not render it moot altogether, and that's a bunch of shit. It's something else I want to go before I go any further. A lot of these so-called constitutional lawyers, they didn't study the Constitution. They only studied what other judges said about the Constitution, making the judge the law and not the Constitution itself. So before we examine those claims, it's important to ensure readers that they have a proper general understanding of the Bill of Rights. Contrary to common misperception, these amendments do not bestow privileges upon the American citizens. Rather, they are a primary set of prohibitions against the government infringing on pre-existing human rights. Evidence in this language, for example, the First Amendment begins, Congress shall make no law. This amendment is not awarding citizens that right of religion, speech, and assembly. It's outlawing the government from barging in on intimate and universal human rights. And the Fourth Amendment asserts that the right of the people to be secured in their houses, papers, and effects against unreasonable search and seizures shall not be violated. Again, the authors are not granting these rights, they are protecting them. And your Congress and your senators are not protecting your rights. When the Bill of Rights was proposed, some feared the enumerated powers of a handful of rights would be misinterpreted as providing a comprehensive catalog, thus empowering the government to infringe on human rights when not specified. That's why they include the Ninth Amendment, saying that the enumeration of the Constitution of certain rights should not be construed or denied or disbarred the other rights that are retained by the people. Let me unzoom this just a little bit because I want to get this all in here, people. Sorry. Amendment 2. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. With that understanding of the Bill of Rights in mind, we see that the Second Amendment, the founders explicitly asserted there is a right of the people to keep and bear arms. What about the reference to well-regulated militia? Okay, it's an operating clause. It sets out specific prohibition against the government's infringement on a right. The right of the people to keep and bear arms shall not be infringed. Period. Now, let's see, if you guys go back here for just a little bit, this is your preamble to the Bill of Rights. I'll put that link in there when I'm done. The conventions of a number of the states having at the time of adopting the Constitution expressed a desire in order to prevent misconstruction or abuse of its powers that further declaratory and restrictive clauses should be added. Declaratory means to fix something that might not be understood. That's why you have your Bill of Rights. And want to make it completely understood. The government is constitutionally barred from infringing upon your rights. Get that through your head once and for all. Don't let these damn Democrats walk over here with their so-called effing gun laws. They don't exist. They're null and void. They're outside the scope of powers that was delegated to Congress by the enumerated powers. Well-regulated militia reference merely serves as to provide a rationale, not necessarily the only rationale, for the operating clause that follows. Well, the Second Amendment stands apart from the other Bill of Rights by having a prefatory clause. These clauses were common in state constitutions of the era. They're usually used to help sell amendments for those being asked to approve them. In particular, American founders were worried of the federal government potential to create a standing army which could be used to destroy state sovereignty and individual liberties. Seeking to sell the amendment by drafting committees and state ratifying conventions, it made sense for the authors to highlight the link between militia and the people's right to bear arms. Given that purpose, that is to cite one more possible rationale. Prefatory clauses don't rightly constrain operating clauses, particularly one as explicit as the Second Amendment, which potentially recognizes the right of the people to keep and bear arms. Even if that clause didn't have any teeth, they're seeking to interpret it as tightly restricting a gun-eligible population run to another wall that the militias are assembled from the citizens at large. Listen to Pennsylvania Trench Cox as he championed the Constitution ratification. The power of the sword in the hands of the yeomen of America from 16 to 60. Summarize the Second Amendment. These people are confirmed by the article in the right to keep and bear their private arms. Multiple state conventions provision of the era which predated the Bill of Rights offered additional confirmation that the armed right of the self-defense belongs to the individuals. As one representative example, consider language of the Vermont's 1775 back up. As one representative example, consider the language of Vermont's 1777 Constitution. The right of the citizens to bear arms in defense of themselves and the state shall not be questioned. Now I'm going to zoom in on that because I want, okay. Language of Vermont Constitution, the right of the citizen to keep and bear arms in defense of themselves and the state shall not be questioned. But Democrats wanted to get their hands on, they wanted more control. Further disregarding the Second Amendment's explicit enumeration of the right of the people to bear arms, some claim the existence of the National Guard renders the Second Amendment entirely moot. Since the Guard, each state has a militia with its own arsenal of arms. Well, that's the thing. The National Guard does have arms. And they are, you know, governor can call them out, so can the president. But they are not the militia. Militia has their firearms at home. The government must keep them in an arsenal, and they've got to be checked every year, make sure, you know, nothing's missing. Clearly, under the federal control, the National Guard cannot be seen as a counterbalance against federal power, thus does not fulfill the Second Amendment's aspiration to enable a well-regulated militia necessary to a free state. The Second Amendment explicitly recognized the existence of a right of the people, not just the current militia, to keep and bear arms. Militia merely announces one rationale for the Second Amendment. Regardless of how militia is interpreted, its presence does not constrain the operative clause prohibiting the government from infringing against the right of the people to bear arms. They are not allowed. And that's what they're doing. They're breaking the law. They're not following the Constitution. I'll put a link to this. Now, I'm going to go back just here just for a second. I've told you people before, the teeth of all these gun bills, you know, you got all these lawyers fighting against the gun laws and stuff. There's one thing they keep forgetting. You see that preamble to the Bill of Rights? And then you have your Bill of Rights. These are your amendments. And it says, This is in 1789, before the Constitution was ratified. Actually, when it was ratified and preserved, it preserved everything for the people. Not for the government, for the people. The conventions of a number of the free states, having at the time of adopting the Constitution, expressed a desire to prevent misconstruction or abuse of its powers. That further dictatory, which I said means that they're fixing something, and restrictive clauses should be added. Thus, that extends the ground of public confidence in the government. Well-regulated militia. Being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. There is no subparagraph A, B, C, D that might stipulate what an acceptable infringement would be, so therefore there are none. Congress and the Senate and the President can all kiss my behind. I'll put a link in there, guys. This is a very good article. Hang on there. Let me get this up here. A Marine buddy of mine found that and posted it on Discord. It's very good. This is what so many people get wrong. They don't understand the Constitution. The more you read the Constitution, the better you understand it. It's like reading the Bible. You can read it a couple different times and you don't understand it. And then one day, after you read more, you understand it better. Hopefully, you people will get this. Thanks for watching.